What is up, everybody? Welcome. Let's get started. Good morning, moderators. I got something interesting. And then we're going to drop the link.
Listen, folks, I know there's a history here. I'd like to get this hearing in today. You know, everybody needs to just focus on the relevant facts, okay? I know there's a history here.
Are you talking up by Sunset Mart? Up the hill by the gas station?
Yeah.
Okay. Why did you...
Make yourself known. Hit that thumbs up, thumbs down. Make yourself known.
All right, who's responsible here?
What's that?
Who's responsible here? Whose house is this?
You haven't been drinking or anything, right?
No.
Okay, drive careful, okay?
Thank you.
This is with the other group that ran away.
Oh, really? You just ditched it? Awesome.
Yeah, those ones kept walking in the car.
It's truly for the win.
Where my Trulies at? Disc that I was given to. So there was 2 different discs. Okay, they all knew about it.
We're not here to talk about the alcohol stuff, okay?
Okay, yeah.
But this is the second noise complaint we've had here tonight within 2 hours.
How are you?
Good, how are you?
Good.
Guys, welcome. Let's see. Adding to the stage. No, we're getting ready for a big hearing on January 23rd. I'll use actually Hector for a second here. I got Ann Taylor is no stranger to, let's use Hector here really quick. So good morning. Share the screen. Hector, what do you got? Well, I got a lot. Let's see. Ooh, okay, we'll go with this. We might have to come back to Hector. Hector's taking a snooze. I have no idea what Hector's doing. Hector, get it together. Oh, wait, maybe this one. Oh, there we go. Ann Taylor, just want to put this on the record. Back in the day, so Ann Taylor did a 3-hour cross-examination of a case. So I'm just putting this out there that if you think Ann Taylor isn't going to go at ever so kindly in a very polite manner, but she most certainly is going to be cross-examining the shit out of everybody. Okay. In this case that needs it, whether, whatever it may be about, but there's none of this going to be like, she has a job to do and she's going to do her job. So in this case, Ann Taylor cross-examined for 3 hours. The father of the 22-month-old that lost his baby, okay, due to allegedly her client killing the baby. Meanwhile, he was never a person of interest, cleared almost immediately, and was the son of an ex-police chief. That's what we're going to be talking about tomorrow night. So he also was involved in the Dobson Pass murders that happened several years before that. So anybody that thinks that Bethany Dillon or anybody in this case is going to get a pass on cross-examination, no, they're not. So next up, bring to the stage. Let's see. Let's see. Good morning, Lana. Thank you for all your dedication to this case. Yeah, I'm just trying to put out the facts. Nothing but the facts. So let's see. Now I want to present something else, which is, here we go. Okay. So we're expecting a big hearing this January 23rd, 2025. And it's all off of numerous suppression motions. And most recently, Ann Taylor has asked on behalf of her client that the motion that they sealed with the IGG, they want it to be unsealed for all of us to see. So also, we have a closed January 21st conference in regards to this case on January 21st, which is Tuesday. I believe that people are going to be showing up via Zoom. There are now 3 subpoenas that have been issued in this case. One is asking for production of material, third party, and to produce, like, hey, you're going to be producing these materials. Deus Tecum is third party. And for example, like, people could do a Deus Tecum for, like, if you're in a civil case and you want to get the phone records of a party that's not involved in the case, you would serve a Deus Tecum subpoena on Verizon for those phone records of whoever, stuff like that. Yeah. Well, we've had amazing. So 3 subpoenas. There's going to be a closed hearing conference January 21st. Then Thursday, we kick off this hearing first thing in the morning at 9 for Idaho time. That'll be noon our time, or I'm sorry, 11 our time, because it's in Boise and we're 2 hours behind. So it's 9 a.m. But if you are East Coast, that'll be at 11 a.m. Now, with all of this stuff, we've seen a lot of within the suppression, motion to suppress the search warrants and the material from them. They're suppressing the material, but from the search warrants, they've put in suppression motions for, a handful of stuff. We all know that. Well, I want to point out something, and it's going to be this. This is a case that I think it was Masseth she cited, and let's see. This is all about in the search warrants and application for them, when it's pertaining to the Apple search warrant, it's very clearly stated that you were asking to search something but not seize it. That's the big argument that the defense has made, one of the big arguments with the Apple For example, I want to use, this was cited. I want to make this bigger. Okay. Does that make it bigger for you guys? It's a little bit bigger. I'll go with this. Okay. So a couple of things that they didn't attach the search warrant, the affidavit, anything. But right here, this is about suing somebody, you know, that violated your constitutional rights. All right. So I want you to see something here. And it has to do about qualified immunity. And so let's get to this. Okay. The warrant was plainly invalid. The Fourth Amendment states unambiguously that, quote unquote, no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized, emphasis added. The warrant in this case complied with the first three of these requirements. It was based on probable cause and supported by a sworn affidavit, and it described particularly the place of the search. On the fourth requirement, however, the warrant failed altogether. And this is what they're saying about these warrants, specifically this Apple warrant. So on the fourth requirement, however, the warrant failed altogether. Indeed, petitioner concedes that the warrant was deficient, and particularly because it provided no description of the type of evidence sought. Okay. The fact that the application adequately described the quote unquote things to be seized does not save the warrant from its facial invalidity. The Fourth Amendment, by its term, requires particularly in the warrant, not in the supporting documents. So it cites cases. But I went on to read, and right here, we do not say that the Fourth Amendment forbids a warrant from cross-referencing other documents. Indeed, most courts of appeals have held that a court may construe a warrant with reference to a supporting application or affidavit in the warrant uses appropriate words of the incorporation, and if the supporting document accompanies the warrant, of which the defense is arguing is not there. But in this case, the warrant did not incorporate other documents by reference, nor did either the affidavit or the application, which had been placed under seal, accompany the warrant. Hence, we need not further explore the matter of incorporation. Petitioner argues, now the petitioner is the person that went and got the warrant, and then took a group of men because they were looking for explosives in a house. Okay. And so respondents was the Ramirez family. They live on a large ranch in Montana. So the petitioner, Jeff Krogh, has been a special agent for the Bureau of Alcohol, Tobacco, and Firearms since 1989. In February 1997, a concerned citizen informed petitioner that on a number of visits to respondent's ranch, the visitor had seen a large stock of weaponry, including an automatic rifle, grenades, a grenade launcher, and a rocket launcher. Based on that information, petitioner prepared and signed an application for a warrant to search the ranch. The application stated that the search was for, quote unquote, any automatic firearms or parts to automatic weapons, destructive devices to include, but not limited to grenades, grenade launchers, rocket launchers, and any and all receipts pertaining to the purchase or manufacture of automatic weapons or explosive devices or launchers. Petitioner supported the application with a detailed affidavit, which he also prepared and executed, that set forth the basis for his belief that the listed items were concealed on the ranch. Petitioner then presented these documents to a magistrate, along with a warrant from that petitioner also had it completed. The magistrate signed the warrant form. Although the application particularly described the place to be searched and the contraband petitioner expected to find, the warrant itself was less specific. It failed to identify any of the items that petitioner intended to seize. In the portion of the form that called for a description of the person or property to be seized, petitioner typed a description of respondent's 2-story blue house rather than the alleged stockpile of firearms. We're seizing the whole house. I'm sorry, I just had a laugh. The warrant did not incorporate by reference the items list contained in the application. It did, however, recite that the magistrate was satisfied the affidavit established probable cause to believe that contraband was concealed on the premises and that sufficient grounds existed for the warrant's issuance. The day after the magistrate issued the warrant, petitioner led a team of law enforcement officers, including both federal agents and members of local sheriff's department, in the search of respondent's premises. Although respondent Joseph Ramirez was not home, his wife and children were. Petitioner states that he orally described the objects of the search to Ms. Ramirez in person and to Mr. Ramirez by telephone. According to Mrs. Ramirez, however, petitioner explained only that he was searching for an explosive device in a box. At any rate, the officer's search uncovered no illegal weapons or explosives. So nothing was found. So when people want to say, why in the world would you suppress something if nothing was found and right? Because I hate hearing this. I'm just so sick and tired of hearing this. Like, why would you even worry and go through the problems of suppressing anything if nothing came from it, right? If nothing came from it, right? Well, because you can make an anthill into whatever the hell you want. That's why. But check this out. So at any rate, the officer's search uncovered no illegal weapons or explosives. When the officers left, petitioner gave Mrs. Ramirez a copy of the search warrant, but not a copy of the application, which had been sealed. The following day, in response to a request from respondent's attorney, because then like, dude, what the fuck? I'm getting this is what people get sued over. Okay. You're violating my constitutional rights. So the following day, in response to a request so Ramirez gets an attorney, and petitioner faxed the attorney a copy of the page of the application that listed the items to be seized. No charges were filed against the Ramirez's. Respondents sued petitioner and the other officers under Bivens, okay? Raising 8 claims, including violation of the Fourth Amendment. The district court entered summary judgment for all defendants. The court found no Fourth Amendment violation because it considered the case comparable to one in which the warrant contained an inaccurate address. And in such a case, the court reasoned the warrant is sufficiently detailed if the executing officers can locate the correct house. The court added that even if a constitutional violation occurred, the defendants were entitled to qualified immunity because of the failure of the warrant to describe the objects of the search amounted to a mere, basically it's a typo, right? Au contraire, motherfuckers. The Court of Appeals affirmed the judgment with respect to all defendants and all claims, with the exception of respondent's Fourth Amendment claim against the petitioner. That would mean against fucking Payne, okay? Against Payne. Like, if you want to talk about this case, all right? Payne, you on the hook. So let's keep on going. On that claim, the court held that the warrant was invalid because it did not, quote unquote, describe with, you have to be very particularity, the place to be searched and the items to be seized. And that oral statements by petitioner during or after the search could not cure the omission. The court observed that the warrant's facial deficit, quote unquote, increased the likelihood and degree of confrontation between Ramirez's and the police and deprived respondents of the means to, quote unquote, to challenge officers who might have exceeded the limits imposed by the magistrate. The court also expressed concern that permitting officers to expand the scope of the warrant by oral statements would broaden the area of dispute between the parties in subsequent litigation. The court nonetheless concluded that all of the officers except petitioner were protected by qualified immunity. That means holy shitballs for Payne. With respect to petitioner, the court read our opinion in United States versus Leon as precluding qualified immunity for the leader of a search who fails to, quote unquote, read the warrant and satisfy himself that he understands its scope and limitations and that he is not defective in some obvious way, end quote. The court added that, in quotes, the leaders of the search team must also make sure that a copy of the warrant is available to give to the person whose property is being searched at the commencement of the search, and that such copy has no missing pages or other obvious defects, end quote. The warrant was plainly invalid. The Fourth Amendment states unambiguously that no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, ready? When you go ahead and you now read, I'm going to share with you guys. Let's see. When you read, let's go with Apple. Where you at, Apple? I think it's right here. Okay. So I'm going to share now. This is the reply to prosecuting attorney's objection. The Supreme Court has acknowledged that a court may construe, so this is Mathis, okay, that a court may construe a warrant with reference to a supporting application or an affidavit if the warrant uses appropriate words of incorporation, and if the supporting documents accompany the warrant and then cited. That's where I got, this case. Now, the Ninth Circuit held that a statement on the face of the warrant noting the supporting affidavits was sufficient as a suitable reference as incorporation. The warrant contained no language that the affidavit was incorporated. The process described at page 5 through 6 of the state's objection lacks proof that the affidavit of search warrant was provided to Apple. The state indicates that the quote-unquote investigators necessarily had copies of the affidavit in their possession when they executed the warrant by emailing it to Apple. See objection. Further, the state offers that the effect of this is that the affidavit for search warrant and appended Exhibit A cure any supposed deficiencies in the naked warrant. See objection, page 5 through, or paragraphs 5 through 6. An officer sitting at a computer executing a search warrant by email to Apple and having the affidavit for search warrant in his hand is different than an officer being physically present when executing a search warrant and having the affidavit for search warrant available for reference. The state has not provided proof, example, transmittal email to Apple, that the affidavit for search warrant and appended Exhibit A was either attached to the search warrant or emailed to Apple as a separate document along with the search warrant. The August 9, 2023 affidavit of Detective Brett Payne corresponding to the return of the warrant has no indication that the affidavit of search warrant with the appended Exhibit A was provided to Apple along with the search warrant. See Defense Exhibit E. To the contrary, the sworn documents states, in quotes, the warrant was served by Corporal Payne on August 23rd, or on August, nothing else, 2023 to law enforcement, Where a supporting affidavit does not accompany the search warrant at the time of execution, the details set out in the affidavit does not cure any deficiencies. This is so accurate. Like, An affidavit is considered to be part of a warrant and therefore potentially curative of any deficits only if, one, the warrant expressly incorporated the affidavit by reference, and two, the affidavit is either attached physically to the warrant or at least accompanies the warrant while agents execute the search. So, ready? Now, go back up here. And I want to break this down. I mean, this is going to be an interesting, like, from the standpoint of how Hitler is going to rule. This is going to be so crazy on how he's going to rule. Because if he's like going to follow the law precedent, like you're you're fucked. If I was Hitler, like I wouldn't want to make this decision. Anyways, I think it's an easy one to make though if you're following precedent. This is when Matt, so this is this, Apple account, federal grand jury subpoena and search warrant. This is what they want to suppress. And it's the reply right here. Securing a search warrant after seeking privately protected information with a federal subpoena does not rectify a search in violation of the Fourth Amendment to the United States Constitution or Article 1, Section 17 of the Idaho Constitution. The words proof upon oath are not synonymous with, in quotes, the affidavit for search warrant is hereby incorporated. I love that. I love that. I love it. I just absolutely love that. Here it is. Now think about this. The contents of the Apple/iCloud are privately protected. Dude, it's the same thing as a phone. My iCloud has everything that my phone has in it. Do you understand that? My iCloud, if I back it up to my iPhone, it has everything. Everything. So the comparison that dialing a person's phone number is akin to a copy of the contents of an Apple account is inaccurate. An Apple or iCloud account is a copy of a cellular phone, iOS, or other device. Without the information obtained by the federal grand jury subpoena, the state did not know what Apple and or iCloud accounts were associated with Mr. Kohberger to seek with a search warrant. All they knew was that there was a receipt for an iPad purchased in 2018 in his car. To collect the records that law enforcement requested from Apple, it had to have a valid warrant. And that valid warrant could not rely on records obtained with a federal grand jury subpoena or a search warrant that recklessly and intentionally omitted material facts. The Supreme Court observed in Katz versus United States that the Fourth Amendment protects people, not places. In finding the Fourth Amendment protects a person's conversations and that a physical intrusion into the area a person occupies is necessary to a constitutional violation, or is necessary. A party has standing to argue a violation of Fourth Amendment rights if his reasonable expectation of privacy has personally been infringed. Through the use of a federal grand jury subpoena, the state learned that the Apple iCloud accounts searched were registered to Mr. Kohberger. Mr. Kohberger's expectation of privacy in these personal accounts is objectively reasonable, which establishes his standing to challenge the search and seizure of those accounts under the Fourth Amendment. Because you guys have to understand, remember that the feds are doing and had been doing their own thing, okay? The feds are doing their own thing. And then after the fact, or then whenever at different points of time, the feds are giving Maori information, saying, "Hey, this is what we went and got. This is how we filled it out. Go ahead and fill it out this way, and that way you can get the same information." But how did you obtain probable cause? Like, so I printed off another case. So in Idaho, we got State versus Johnson, we got Smith versus Maryland. That's a Supreme Court case. State versus Johnson. In Smith versus Maryland, for example, the United States Supreme Court concluded that the person on whose telephone line, this is for the pen, trap, and trace, whose telephone line the pen register was installed, in quotes, in all probability, entertained no actual expectation of privacy in the phone numbers he dialed, and that even if he did, his expectation was not legitimate. Therefore, the court has held there was no search and no warrant was required. We recognize that so far as the protection provided by the Fourth Amendment is concerned, both state courts and lower federal courts are bound by Smith. We are convinced, however, that in Idaho, there is a legitimate and reasonable expectation of privacy in the phone numbers that are dialed. Remember when Ann was asking, what did you rely upon to get that second warrant? So she has him pinned down in and under oath. And he said he relied upon, the cell phone records of the survivors and the victims. That has nothing. He relied upon cell towers that nothing's there. Everything that he's saying that he relied upon, you would not get probable cause. Also, where is this? Okay. The district court correctly suppressed the evidence obtained from the wiretap. Ready? Since there was no warrant based on probable cause for the installation and use of the pen register in this case, the information obtained by its use should have been excluded. So this is like it was overturned. It should have been excluded from determination of probable cause for the issuance of the wiretap orders, State versus Johnson. The question with which we are then presented is whether, without the pen register information, there was significant evidence to establish probable cause for the wiretap. And in this case, that's where we're getting into, okay, yeah, without this information, without things that came from stuff, could you then continue on? The state itself acknowledges. This is why the state has maintained that nothing has come from IGG. Nothing has come from IGG. Nothing has come from IGG. Okay, remember, nothing has come from IGG. So think about this. The state itself acknowledges without the pen register, the police in this case would not have been able to develop probable cause for the wiretap, which eventually produced significant evidence to justify a charge against Judy Thompson and her co-conspirators. Appellate's brief on petition for review, page 18. 2 wiretap orders were issued by the district court authorizing the wiretap of Thompson's telephone. The affidavit that was offered in support of the application for the first wiretap order stated that the data obtained from the pen register installed on Thompson's telephone line indicated that Thompson was contacting a residence in the Twin Falls area where a drug supplier lived or frequented. The affidavit also stated that the pen register data indicated that Thompson was contacting females who were making visits to the Idaho State Penitentiary, the location where the law enforcement authorities believed drugs were being delivered. In addition, the affidavit indicated that the data obtained from the pen register showed a high frequency of phone use by Thompson, 1,100 calls in 43 days, excluding calls to or from Thompson's place of work. The officer making the affidavit concluded that Thompson's phone activity was comparable to the frequency of calls of other drug traffickers and that Thompson was using the telephone to distribute or sell illicit drugs. Other than this information that was the result of the use of the pen register, there was no information contained in the affidavit indicating that Thompson was using her telephone to conduct any drug-related activities. The officer who made the affidavit stated it was all speculation. The same thing that Payne did. The same thing that Payne did in his affidavit, that he assumed, like, oh, he shut off his phone. Oh, he shut off his phone. So, in quotes, because of the large geographical distance between Judy Thompson and her probable source of illicit drugs in the Twin Falls area, the likelihood of the use of the telephone to conduct transactions increases. Because she can't go, have these in-person, chats. She has to use the phone. And the affidavit also states, through various other independent sources of information, we have confirmed that Judy Thompson is using the telephone or telephone devices to transmit types, quantities, and prices, and or other means used to distribute or sell illicit drugs. Ready for this? No further indication of these, quote unquote, various other independent sources of information or their reliability was contained in the affidavit. The affidavit offered in support of the second wiretap order alleged as a basis for the extension of the wiretap for another 30 days that during the period covered by the first order calls had been intercepted, indicating an ongoing conspiracy between Thompson, the drug supplier in Twin Falls, and others to supply Thompson with marijuana, which she would then distribute to others, including those who would smuggle the marijuana into the Idaho State Penitentiary. Thompson's motion to suppress sought suppression of the information obtained through the wiretaps resulting from both the orders. Since the second order was based on the information produced by the first order, we must determine if the first order was properly issued. If it was not, none of the information obtained by the wiretaps were admissible. Since the basis for the second would be tainted by the illegality of the first, State versus Johnson. Again, on the other hand, if the first warrant in the order was valid, none of the information obtained through the two orders should be suppressed, right? So we have adopted the totality of circumstances analysis as the standard by which probable cause would be determined in Idaho. State versus Lang. This approach is appropriate for determining probable cause under the Idaho wiretap statute. Before a judge may enter an ex parte wiretap order under this wiretap statute, the judge must determine, on the basis of the facts submitted by the applicant, that there is probable cause, 1, for belief that an individual has committed or is about to commit a particular offense. So remember when Payne's talking about how could something be determined if something already had happened, right? And so putting down a pen, trap, and trace, how is that showing you that that's evidence of, because something that you're trying to look at in the future is evidence of something that happened for homicides that happened however many months ago, right? At that point, what? 6 weeks, actually. Number 2, for belief that particular communications concerning the offense will be obtained through the wiretap. So, again, and then 3, for belief that the facilities from which or the place where the wire or oral communications are to be intercepted are being used or about to be used in connection with the commission of such offense. So in Lang, we held that in reviewing findings of a judge who issued a warrant, our function is limited to ensuring that the judge had a substantial basis for concluding that probable cause existed. So in Lang, this is where it's going to come up, like, did Magistrate Megan Marshall, okay, based on the information that she was provided, okay? So in Lang, we held that in reviewing findings of a judge who issued a warrant, in quotes, our function is limited to ensuring that the judge had a substantial basis for concluding that probable cause existed and that, quote unquote, this is when you have to give great deference, is to be paid such determinations by reviewing courts like you have to show a lot. Reviewing the affidavit of the officer in support of the first wiretap order, we concluded that the district judge had a substantial basis for belief that Thompson had committed or was about to commit the crime of dealing in marijuana, one of the offenses enumerated in IC whatever. Excluding the information obtained through the use of pen registry, we concluded that there was not a substantial basis for belief that, quote unquote, particular communications concerning the offense would be obtained through the wiretap, or that Thompson's phone was being used or was about to be used in connection with commission of the offense. In parentheses, those comments of the officer that there was a likelihood that Thompson and her Twin Falls source might use the telephone to conduct transactions is only speculation and does not create a substantial basis for probable cause. You guys, this is everything that Payne was saying. Like, Also, the statement of the officer that, quote unquote, various other independent sources of information confirmed that Thompson was using her telephone for dealing in marijuana is not a substantial basis for probable cause, since there is no indication of the veracity, reliability, or source of knowledge of these other sources. So, as this court pointed out in State v. Johnson, even under the quote-unquote totality of circumstances test, the veracity, reliability, and basis of knowledge of the persons supplying hearsay information are all highly relevant in determining the value of his report. And in making the determination of probable cause, the judge's action cannot be a mere ratification of the bare conclusions of others. Wow. We concur with the analysis of the state that without the pen register, the police in this case would not have been able to develop probable cause for the wiretap. We reversed the decision of the Court of Appeals on this issue and affirmed the suppression under the suppression order of the district court. Damn. Well. State versus Thompson, baby. State versus Thompson. We we hold that the use of a pen register is a search under Article 117 of the Idaho Constitution, that the evidence produced by the pen register should not have been considered in the issuance of the wiretap orders, and that without the pen registry evidence, there was no probable cause to issue the wiretap orders. Therefore, we reverse the decision of the Court of Appeals on this issue, on these issues, and affirm the order of the district court suppressing the evidence obtained from the wiretap of Thompson's telephone. Because you can't just fucking say, I think, or like, I mean, this is a shit show. So here we go. Here's this amazing link for anybody that wants to voice their opinion on the shit show of all of these search warrants that yeah, so we have Hitler over a barrel with this. Would you say? I think that not over a barrel. I think it's going to come all down to they're going to have to show proof. The state's going to have to show a lot of proof that they didn't rely on IGG when they're saying this whole time, that they did not, but then they really did. So, hey there.
Hang on, let me kill off my YouTube. Hang on. Okay, I'm sorry.
You're good. How you doing, Sarge? Good to see you.
Well, I'm doing awesome. I mention you often on my show,
Oh, good. You better.
From your cackle to your research here.
Oh, sweetness. Yeah, this is, I mean, this state's gaslighting.
You know, it's worse than that. Can anybody show in the PCA that it is not a theory? This is why I got into true crime. If it weren't for the horrific incidents and the way the police handled it, you guys wouldn't even know me here. I'd have stayed in politics. That PCA is a theory.
Yeah, it is. It's a theory.
He turned off his phone. Where's that probable cause? How do you know he even did that? Where's your witness? Did he admit it? Did he admit to turning off his phone and to hide himself from a crime he was going to commit later that evening? No. Well, so how is that not your opinion that his phone disconnecting from a network is a preempt to a crime?
I mean, exactly.
Right. What about all the locations of the? I'm sorry.
And then I think it's going to come out though too that he'd only been at that time a law enforcement officer for 2 years. So your experience is shit. When he says like my training and experience, that people turn off their phones when they're going to go commit a crime. Can
you or anybody
Can you prove
else,
that it was turned off?
Can you prove that car had anything to do with this crime at all? And you're the most in-depth reader of data. Show me in any of the data or in any of what you recollect that any car at all is conclusively tied to that home in this crime.
No, I haven't seen it. That's another thing is if you're going straight off of Linda Lane, you can't even see what cars.
No, go off the PCA and the movements of that vehicle. What makes that vehicle part of this crime? What piece of evidence connects it to the crime? That's
Dylan's statements. Dylan's the only thing
that
they're
she doesn't identify a car, but she doesn't identify a car.
No, it's speculation.
There you go. Is that probable cause?
Well, according to State versus Thompson, it's not.
Is him suggestively turning off his phone probable cause?
No.
Theory. Okay.
No, even if he did shut off his phone, just because somebody shuts off their phone from 50,000 students, you know, probably phones were either, who even says that it was shut off? It could have died. You know what I mean? But
well, did you collect and turn over a video of every single vehicle that was in that neighborhood that night and examine whether any of those people did get out of that vehicle and approach that home?
Yeah, no.
In other words, if there were 50 cars on camera that night, did you review all 50?
That answer is going to be no.
Why not? What makes this Hyundai Elantra so important?
Because we had that sheath, baby. We had that sheath, and we were just waiting to get that DNA because we had that sheath.
That's what the guilters stick to with the DNA. But the DNA is going to be inadmissible because of the approach they used to get to it. Their probable cause was non-existent. His travels that night never put him at that house. As a matter of fact, his witnesses for his alibi are the police that put together the PCA. They do everything but put him at that house. Fair enough?
Yeah, I think so.
The FBI
and they found every reason to ignore actually the evidence. The evidence that he wasn't there. You know what I mean?
The 11 to 13 identification kills the whole case. Do you agree with that?
The 11 to 13.
The FBI agent that's standing tall that he identified in 11 to 13 at the crime scene.
Oh, yeah. Yeah, 100.
It was Brett Payne that it was later determined.
Yeah, it was Brett Payne. Yeah, and that's where I believe that Emil is going to be. I think he's going to be there. You need to ask Emil when he said he changed his opinion.
He didn't.
Well,
he didn't.
You have to ask that.
I know, but so far what we do know is that he was shown a separate photo from a different location that was a 14 to 16. He admits that. He also admits
that's the WSU stuff. But I'm even saying he saw a different. Whatever he saw on Moscow's campus, that was on, according to Jay, Ridge Road going the wrong way at the wrong time. It wasn't even like the 1118 or the 1112. These ring cameras. They're talking about Linda Lane. I don't believe that he was shown anything when they want to talk about that immediate area. That's the immediate area to me. It's going to be it's king or queen. That's your immediate area. When you're going outside of that, whatever.
When asked if any of the video at all conclusively shows Bryan Kohberger or Bryan Kohberger's car, and they say no.
Yeah, no.
What do you mean no? How could it not? You're alleging this guy committed the crime in a car, but none of your video can confirm that.
And then And then when you even obtained the damn people can obtain search warrants before you arrest somebody. So why not obtain the search warrants to search his vehicle, search his apartment? Why do you have and see if there's actually stuff that comes from it? They did all of this in a big shebang. Why?
They did it backwards. I
mean, it's really weird if you ask me. Even in Richard Allen's case, they served a search warrant on his house. They didn't arrest him yet. They then ran whatever to the lab, and so I'm just saying, why in this case would you not get search warrants for those things and then see what they come back with?
Well, the search warrant, what I think should have happened here, and I think you'll agree, was once the idea of Bryan Kohberger became a possibility, then the swabbing, the bringing him in, the questioning him, and the investigation of him is supposed to begin then. Not after you arrest the guy.
Yeah. Well, see, for me, after all this research, I believe that the FBI was totally conducting their own, and they were doing all of their own things when it was determined that Bryan Kohberger was not going to Idaho was not giving up the jurisdiction. Idaho said, this is our case. You know what I'm saying?
Yeah.
And if they're not going to relinquish anything, then it's up to, okay, now are the feds going to, so the feds had Bryan way before they then told Moscow Police Department anything about what they were doing. And then I'd be speculating to this, but I can at least tell you for a fact that December 6th, you would never put on a warrant to look for, a replica sheath, and then stop at December 6th. If you don't have this guy and you're not arresting him until December, 30th, that warrant is going to encompass all of that unless you copy, cut, and paste from what the feds did. And that's exactly what they did. And that's Mowry giving up the fact that the feds, how did the feds and why did the feds do a search warrant for Bryan's Apple and all of this shit December 6th, 2020? That means to tell me you had his name, because they already had his name, because the IGG came back way quicker than they're trying to say. Yeah, Moscow found out about the IGG on December 19th because the feds didn't turn it over to you until then, because the feds kept your asses out of this.
And the other thing too with the IGG is I don't think a lot of people realize that if I go and I pick up a random DNA sample out of a supermarket and bring it to a place to review without a name, you might as well just wipe your butt with that DNA. You need a name specific to start to build a tree. You can't just build a tree because we share too many markers. For instance, when you get a paternity test, there's 12 markers they look for between you, the man, and the child. And it's the amount of markers that match. And let me tell you that any white European male between the ages of 25 and 35, okay, of which there might be 250,000 in my area, are going to have some of those markers, if not one, multiple markers. The question is, how many markers match me and the child? Is it 9 out of 12? Is it 10 out of 12? Is it 8 out of 12? Is it 12 out of 12? Is it that? So to try to build a tree with no identity is extremely difficult. And even Ann brings that up in her motion with some of these arguments under the IGG. You need a target.
Well, if you have a database and you're inserting my raw data against everybody else's raw data that they've already uploaded, you're going to get all these certain hits back.
Yes.
And then it's but then you have to determine who are these people to me? There's no, I don't know who these, you know what I mean?
And can you go down the wrong road?
And so what I have to do then is, so you are going to get hits back. It's just now, but if you have a parent that's in that database, or you have a sibling that's in that database, your markers are going to be way up here. So those are the ones that you're going to work with. But if you have a parent or a sibling in that database, when you enter your shit in, you're going to get, those are going to just be sticking out at you like a sore thumb from everything.
I want to say this before I jump down. I watched one of your videos the other day about Steve G, where you were talking about Steve. It's a few months ago.
Okay.
But in that particular video, I don't know if you realize it or not. You probably do. So I'm probably singing to the choir. But Steve G tells us where the other DNA was found in that house. He tells us that it was on the pant leg and on the arm of one of the victims. He interprets that to mean that that's all Bryan Kohberger's DNA. But what I think most people are missing is he was told there were multiple sources of DNA, where they were located, and doesn't understand that what he was really hearing wasn't a conclusive idea of Bryan Kohberger, but that DNA that was found in the scene was on the sheath, was on a pant leg, it was on somebody's arm. And they were all different DNA. There were 3 DNA samples, all different. He didn't know that at that time. I don't know if you picked it up when you were doing your stream or if it dawned on you that when you read that one statement that came out of the courts where they had found 3 male DNA within the house in relation to the crime scene, that now I think we know where those other 2 DNA sources came from based on what Steve got leaked out to him. He interprets it all to be Bryan Kohberger's, but we know there's only one source of Kohberger's DNA in that scene and 3 unidentified.
Yeah, that's correct. I think Steve has, like when he's being interviewed and stuff, there's never been an interview where it's not been cut. So I would just like to see Steve being asked questions that there's nothing being cut, changed, edited, something being put. Because it's like, if I ask you a question and then we're talking, but you don't get to say your whole answer, or I don't start your clip from exactly right after I ask that. And, but he's reciting things too that he's heard. And he's just, I don't necessarily think that he's like, he's just saying stuff. He's just saying stuff. And I don't try to put too much stock into that, because I know for a fact they've gotten confused on a couple different things. And it's just like a parent, you're trying to get all the information that you can. Your kid has been murdered, and you got people coming out of the woodwork messaging you. You know what I mean? So with that, then the police, I could tell you this: the police were giving him information, and then all of a sudden, the police decided they wanted to make it known publicly to all of us who did not need to know that we're no longer giving the family any more information either. And I think that the PD had to do that because we're not the ones supplying Steve with this information. Steve is saying stuff and it's not from us. So I don't know where he's getting this from. And I think that they needed to make that known, so much so that they put out a damn press release about it. And that was on December 1st. But when Steve did his interview on November 20, it was a Wednesday, November 25th, 3rd, whatever the Wednesday was before Thanksgiving. And he did one on Saturday. He's like, I haven't heard from them. I haven't talked to them. I haven't heard from them since last Wednesday. And it's like, well, I don't blame the police in that sense of just like, dude, we're telling you things and then you're going out and telling everybody else. I don't know why he was doing that.
In the stream,
it tells me that he doesn't have respect for them and he doesn't trust them, if you think about it.
In your stream, you say Steve Gonclaves talks DNA on sleeve and leg, and I listened through a bunch of that stream. Oh
God, yeah, that was a while ago. Yeah.
But let me just this is what I'm referring to. Listen, I give Steve all the leeway in the world. I can't even, and none of us can comprehend what that family's experienced. So I don't care if the guy comes out and says aliens abducted this. I'm gonna not really have any problem with it. But when he makes a specific statement, whether he knows what he's saying or not, and he came forward and talked about the sleeve and the leg.
Yep.
And we now know that they had 3 sources of DNA, male DNA, in the crime scene, right? And he acknowledges the knife sheath. He acknowledges the knife sheath, and then he throws out leg and sleeve, thinking it's all connected to Bryan. I don't think he's telling you a story. I think he's telling you what he heard.
I think he thought that, and then he realized that it wasn't true. Is that what you're saying?
No,
he realized
I think that he was really told that by the police. I think he was told that by the police in such a way that he assumed it all meant it was Bryan.
Yeah. So here I'm gonna pull up that live. It was the one that I did
here if you want it.
Oh, you do?
Yeah, I sometimes can't catch your lives. I pop through a lot of people's shows.
So Steve, I think
it's in the private. I think here.
Oh, it is. You did that? Okay.
Yeah, I just linked it to you in the private. But just follow my reasoning here. The warrant, the information does show there were 3 additional single source male DNAs, 1 on a glove, okay, and 2 inside the home in relation to the crime scene. Steve now has come out and said that he's been told that they got Kohberger on DNA on the leg, on the sleeve, and on the sheath. And what I'm suggesting to you is he was allowed to think that. that he was told that these were the locations of the DNA and that is accurate.
Mm-hmm.
Okay,
But,
but the
yeah.
description of who
Somebody didn't change it.
is not right.
Yeah, somebody didn't change that. Like, someone let him believe that. Is it
family?
Correct? They let him believe that because they want the parents not to fight them. They want to bring this to trial and try to get a conviction. They don't want the parents on a different team. And so they were feeding them information. And I suspect that what happened here was Gonzalez was told truthfully where the three sources were in the crime scene, because they weren't going to take a swab from the washing machine in the basement. They were going to look for DNA that only had a pertinence to the crime. And so the only DNA
I agree with you on that.
100%.
Right? I agree with you on that. And
Okay.
I mean, and also if you think about it, they only took whatever they took out of there. There's only 110, and then it changed to 113. So I don't think that they're taking, swipes like you said, like.
No, they're going to swipe areas that are connected to the crime scene, the areas that they would have traveled, areas and things they would have come in contact with, from including the doorway leading around to the staircase. They may have put their hand on the wall, the railings, the steps themselves. They're not going to test the front door because they're understanding the man used the sliding door. Personally, to me, Lana, this crime scene was so perfectly sealed. There was no doors that have ever been alleged to be forced, including bedroom doors, including entry doors, that for anybody to say that somebody came in from the outside, you can't prove that. You just can't.
Yeah. Yeah. There's no, to think that,
an intruder
to
did
think
this
that,
is kind of,
yeah.
sorry. Yeah, I get passionate about it because
to hear parents say like that, hey, they were notorious for like they did lock their doors. You know what I mean? There was just somebody just changing, this, that, and the other. And then to hear like what the front door and the slider, both were totally unlocked. Like it wasn't like just one
undisturbed, unbroken into. There was no broken glass. There was no jimmied window. There's no mention of any forced entry to any area of that home. And we all know that every door in that home had its individual lock.
The cross of a lifetime is going to be Dylan Mortensen.
Correct.
Because if she changes at all that time of when she saw this person and that can be moved, then they're going to lose their case because their case relies on that crime happening in that very, very small window of time. And it's literally relies upon the words of Dylan and saying that. And then how are you proving that what she even saw and heard happened at that time?
Right.
When you're going to find pictures. And remember, they took all these 67 downloads, of all these phones to go through all these pictures. If you can prove that Dylan was off her rocker as far as drinking or, doing illegal drugs, for her to know what time it was and the cops to say that, and for her, when did that become, remember it was, she was downstairs and both, people slept downstairs.
Yeah, they started.
When did it change that she slept upstairs? And if they're going to come out and say, well, we weren't going to tell the world that there was a witness and then put them in danger by the person coming and killing them. You know what I mean? Like,
you want to hear something? If
there is no witness, I don't believe that there is a witness.
No, I'm going to say this too, and this kind of just hit me,
anything.
and I'll jump down in a second after I share this. Look, I suggest a crime scene is too clean to indicate forced entry from an intruder. Nothing indicates that. I say this, folks, because I myself was a criminal. I was investigated many times. I beat many charges of crimes I actually committed. Okay. There's a process you have to go through.
And he is talking about it right here.
Those are not constitutional rights. Those are constitutional limits the government must not cross. You don't have a right to free speech. You have an imminent, forever gifted by God, whether you believe in him or not, to free speech, and the government cannot infringe. The government can't violate your Fourth Amendment. It's not an amendment that's giving you a right. It's telling the government you must not do this. You see? That's a lot of folks don't realize you're not granted a right in this country. The government is told you cannot do this. And when you violate that, that's why court cases get beaten. But I would just want to end with this. There was a case in September 2021 that nobody talked about, nobody told us anything about, to which a man of approximately 5'5" entered a home of sorority girls and entered a bedroom with a knife and was kicked in the gut and fled. That man at 5'5" tall, from Dylan's perspective, from her freaking doorway, would appear to be 5'11" tall. Because when you go from Dylan's doorway to the living area, there's a 6-inch step. Okay? That 6-inch step is not mentioned. There's no ambiguity in her description. She said he was roughly 5'10" to 6 feet, which perfectly describes that man from September 2021. You have to understand that where she stood, that man would have been face on to her. She would have been almost the same height as the perpetrator. If it were Bryan Kohberger, her description would say 6'6" or taller, because his walking towards her from the living space would include an additional 6 inches in floor height. Do you follow me?
Do you think it was 6 inches drop off? Because you think it was 6
Yeah,
inches?
I got a video that proves it. I got a video that proves it when Zana is walking from the kitchen into the living area. Her head is equal with the first landing on the staircase. The top of her head is level with that. When she goes from the landing in front of Dylan's door into the living area, her whole head is above the landing on the staircase behind her. I got video proof of this. The house shows it being a step up from her room to the living space. Therefore, your suspect had to have been shorter. He couldn't have been Bryan Kohberger.
Yeah, when
He
I
would
always
have
think
been
of 6 foot, I
6'6"
think of like dick size. So I'm thinking, is that like, you know?
I'll show you the video.
I want to see. Yeah, I think that they should look at how tall that step up is, because you have to take that into account. Absolutely.
And she didn't in her
I don't
description.
I don't think that who's ever walking past there sees somebody there, or that you could possibly even miss them. She'd be dead, you guys. She's a goner. The same reason that Xana was a goner. The same reason that Ethan was a goner. Like,
do
if you're not
see the
there, the
significance
reason
of
that
what
I believe that those two are alive is because they weren't where they say they were.
I don't think that's true either. I think it could be even more nefarious than that.
Well,
sorry. There's no fourth entry.
They're not alive because they did what they said they did. Let's just put it that way. There's no way
Okay,
that Dylan is standing there. He's just like, oh, you know what? I'm tired. I got to get the hell out of here. And then she doesn't call 911 or either one of them for all those hours, but knew to run in her room and lock the door. Get the fuck up out of here, man. Are you? That would have been something that would have been like
what if I said this to you? What if you open up your door and you said it's okay, I'm here to help you?
I would be running into that person's arms.
Was that a statement made to Dylan, or was that a statement Dylan heard? My point is that
she heard it.
Okay,
How
I know that's what she's saying.
For anything, I think that every officer should be then under scrutiny.
You can make a better case that crime took it was done by people that were already on the premises, and the only persons and people that we can confirm were there before, during, and after were through their own admissions, Dylan and Bethany. That's it. You know they were there. There's no forced entry. There's no reason to say that anybody pried their way into this home from the outside. They broke down a bedroom door.
Actually, same thing with, they're 2021. That person just was one of the windows slit open or something.
Yes.
But there was no big deal made about that. It was like, we don't know. It just looks like it could have kind of been, but remember, like the door was unlocked. So like the person just walked in. Very interesting.
Wait till you see that video of Zana walking from the kitchen to that room. A bulb is going to burst in your head. You're going to say, holy shit. And here's the other reason why I say that matters. Her statement is, he was walking towards me. And you can't walk towards somebody coming down a flight of stairs in a hallway that's only 5 feet long. You can, in other words, her door opens in a way.
The hallway is it's not even like a hallway.
No, it isn't. It's like a step from one room to the other.
It's just a little square. It's crazy.
So for her to is it fair to say that then you can suggest that her seeing him face on means he walked from the living area towards her? Is that fair?
I could say, like, he walked towards me. I would have to be peeking out of my bedroom. I couldn't be
looking. No, don't use the word peek. She never said that. She said she opened her door and looked out.
Yeah, and the reason I say peeking is because who opens up their door 3 times? And like, that's what I'm saying. Why is she going like this? Why would it not be all the way open? If you opened up your door all the way and you're going to sit here and tell me that whoever this person is walked right past it, A, didn't see you, but then B, didn't fucking do anything to you. and just was like, oh my God, I'm just too tired or whatever, and got out of there, I'm going to call bullshit on that.
Well,
You know,
I think
what's another person?
Her whole story, when you look at the details, makes it more likely she was aware what was going on in that home, and her actions are consistent with that. If you use that point of view, and I'm not saying she was, but I am saying,
I'm saying these.
I can make a better case Dylan was involved than Bryan.
Yeah, but
I
these
can make a
police
solid
in
case.
Idaho, the way that they operate, these Idaho State police officers, the way that they operate is, you're going to give me what I want and what I need, or we're coming at it like that you did it. So you're going to tell these cops, or they're going to tell you, and here I'm going to show you guys something too. These people are going to say things that you want them to say, that the law enforcement wants them to say. That's why it's important to find out body cams. When did Dylan give all of her statements? Because right here, I'm going to share it.
Did they strip search her?
And did they strip search her? Check this out. So this is from a case. It was a drug case. And so it was a appellate brief here in 2014. But it was for a case a little, before that. But this is one of the people that they used. They use people that are jail, like informants and shit. And so this is in Kootenai County, Idaho State police officer and a prosecutor being accused of. Specifically, Mr. Reed noted that there was evidence that Mr. Rollins had recanted his story of Mr. Reed's confession and behavior while in the jail, and further stated that he had been bribed for the statement by the prosecuting attorney. Evidence that the prosecutor gave Mr. Rollins transcripts of others' written, recorded testimony to read prior to making his statements against Mr. Reed. And evidence that Mr. Rollins' girlfriend told a PSI investigator that Mr. Rollins is a pathological liar. To see that, and is somebody going to have, okay, hey, talk to this man, right? But he stayed up saying that a prosecutor, because this all came in the phase of the sentencing. This is prosecutorial misconduct. But what is being accused here is everything that I'm talking about, their tactics, their ways. But here you have a prosecutor that's being accused of basically, hey, we're going to get this jailhouse informant, more or less. It'd be like somebody coming up and saying that Bryan Kohberger is saying all this stuff to me while in county.
They approached me to do that when I was in jail. Yeah,
this is what they do. It's fucking sick. This is who they are. So I'm going to give Dylan the grace right now until I see some of these, like whether I see a body cam of the interview, but I'll be able to to formulate the dates that these were happening on when she was interviewed, what she's saying. But if people are going to come at me and say, okay, well, it looks like you did this. There's nobody broke in here. You're up. You're running around. You're on your phone. You want us to believe that you were sleeping. What it looks like, what about your boyfriend here? We know that he's involved in drugs. We know that And then so you're going to start telling people what they want to hear. And that's how Idaho State works. And so I'm curious if this happened with Dylan. And if it didn't, then it didn't. But
is it shown that they apprehended everybody that was at that crime scene when they arrived and put them all in separate cars and separated them and interviewed them all? And
they didn't even know who was there. Remember? We don't even know who was all there.
I mean, don't you think that's part of crime scene? You have to expect everybody as a suspect that's there at the crime scene, even if they're not, even if they're a neighbor across the street. You have to separate all of them people and question them individually and determine whether any of these people may have involvement or not. There appears to be none of that done. They talked to Bethany, they talked to Dylan, but it doesn't appear like, did they hold them? Did they bring them to the police station? Did they separate? What did they do?
No, we have the chief of police saying that we don't even know who was there. Right. Well, then let's get out your body cams and start looking to see who the people that were there. You know what I mean? And I said, wait, Bryan Kohberger, allegedly his car went back there the next morning, remember?
And they confirmed it didn't.
Well, not only that, but they're saying, no, I'm talking about like the next day, like meaning like that morning. So not like the 14th, but like the 13th at 9. It's in the probable cause. Right.
Yeah, I saw it.
You have all these motherfuckers with go get the cameras. All these Ring cameras that are clearly you're able to see all this stuff. You would see Bryan's white Honda Elantra just strolling up because he's wondering why isn't I've been listening to the scanner all night and nobody has called in a 911 call. Like what the fuck? So then he gets in his car and he goes over there. Like that's what more or less they're saying. If he went over there around 9.
But didn't they say that his car wasn't there that day? Didn't they come
No,
back?
that's
and
the
correct that?
14th. No, that's the
Okay.
14th.
Okay.
I'm saying in the probable cause, they said that he went back there and he left Washington at 9 and he arrived at 9:12. And I was like, damn, you'd be flying. We drove that. You can't make 12 minutes. Get the fuck out of here. You're not making that. You have to be flying. And then he was there until 9:22, I think. And then they said, that's when he drove back. And they were trying to allude that he went back to the scene. And it's like, you have all those cameras there because of all these rings. It's very simple. Like
Well,
that would be like
listen, on the IGG, I'm
Ridiculous.
going to share this with you. You may know this. Amanda Knox was convicted in Italy for murder. And do you know what cleared Amanda Knox of murder? Do you
the
know why
shit
they
in the
threw that
toilet.
case out? No,
The
no,
shit in the
because
toilet.
because not only was it just transfer DNA, but there were other transfer DNAs that were unidentified at the crime scene, involved in the crime scene. So when you find other
Yeah,
additional DNA
that was
on
the
the
shit.
victim,
That was the shit in the toilet. The feces in the toilet.
so you have unknown DNA within the crime scene. How is it that you can conclude conclusively that she was the one that did the stabbing? You can't. You have to be
Yeah,
able to
and she
identify
lived
all
there.
potential suspects, right?
And she lived there. Of course, my DNA is going to be in a place that I lived.
Right.
Versus like an unknown. You know what I mean?
Mm-hmm.
So
And there's
we have
another case where,
unknown male DNA in a home that was around the victims. Okay, and that it was in the area of where the victims were, found. And so it's like, I agree with you. How, when you want to say that this is just one perpetrator, you've got to have your experts showing that there's wounds that no way a K-bar knife could make. If
Well,
you can make
in
that
a case-
argument with this other DNA and,
a black guy was convicted of murder because they found semen in the victim, and he argued, in fact, that he had lawful sex with the victim. It was, in other words, when he found out she was dead, he freaked out. He couldn't believe it. Well, they convicted this guy of murder, but guess what?
Isn't that crazy?
On appeal, they were able to produce from the prosecution documents that showed trace DNA in locations that would be consistent with somebody involved that did not belong to the convicted, and they had to overturn the conviction and release this guy.
Yeah.
So here's the problem with transfer DNA, folks, is even if it's at the scene, if there's multiple sources of transfer DNA, you don't have a case. You just don't.
And then when you just have so many holes like this, though, and you find out how they violated his rights and how they try to put 10 on 2 with, okay, hey, we need to pile on with the evidence. Let's just say that the car and the phone were moving in this fucking crazy ass loop. When you do that after you're showing your shitty ass practices that when you're doing this, and then you want us to believe that the sheaf wasn't planned and it's on the up and up, but yet it led to nothing. Like it led to nothing burgers. Unless you're going to tell me that there's fucking DNA in his of the connections, nothing, everything that they did, all these fucking fruits would be. Where's all the fruits? There's nothing.
Well, where's the dog hair in a house that was that unmaintained? You saw the kitchen. Where's the dog hair in Kohberger's possession? Where's anything connected to that crime scene laid at the feet of Kohberger? There is none. I think there's going to be a new term. You've heard of Murphy's Law. I think there's going to be a Kohberger's Law, and that being unlucky would be Kohberger's Law, right? How his DNA ended up there, none of us can say, right?
Yeah.
But here's what I said. I don't think Kohberger's innocent or guilty. I give him the benefit of the doubt, and I give our system the chance to vet this out, right?
Yeah.
So
That's what I tell people all the time. I'm like,
case,
I don't know if he's guilty or not. I was like, we have to let it. Where's the state has a bunch of evidence. Like it's just the probable cause.
It's not evidence. It's just an opinion, though. There's no evidence that he
Yeah.
turned off his phone. There's no evidence that was his car driving around that house. There's none.
Yeah, no,
It's an opinion.
It's their theory of the case, and
Right.
we don't convict people on theories if there's reasonable doubt. That's supposed to be the thing.
We don't arrest them on theories. You don't issue warrants on a theory.
That's to me why they did it the way that they did is because they knew that there were going to be no fruits from the search warrants. Do you understand? If you know that you're going to because I'm waiting to get those back to then go arrest him.
They searched the 15 Elantra
there would be nothing coming back.
They searched the 2015 when the FBI had confirmed it was 11 to 13. That would be like me searching your house for a crime that happened next door to me. What am I doing at your house, Lana? Makes no sense. If you identified at 11 to 13 around that house that did all that driving, right?
Mm-hmm.
And then you go and search a 2015 and find nothing, why would you be surprised? What I'd like to see them do is show a point in time where two Elantras were in proximity to themselves, and one of them was Kohberger. So here's how he could have done it. He could have got out of his car and got into another car Exact make, model, different year. Drove over and committed the crime and left. You need to connect Kohberger to the car that the FBI agent
in 2013.
Say that
or
again.
If you attempted to disguise your car and change the modifications.
Correct. You
that's
need
what
to
I was
connect
talking
them
about
to
the
that
other
car.
day.
And then even worse, then you could connect them to his DNA sample, but there's no evidence connecting him to that house except for a DNA sample, and that's not enough for a conviction.
You know, the other thing that's funny is I tell people this all the time. I'm like, you know what? If I was just to come forward and to say what the police are saying, and I would be labeled a conspiracy theorist. Like the way that they're just throwing all of this shit. It's like, wait, if I said what the police are saying, or you did, or any of us had the theory that the police have right now with only what they have that we know in the public, everybody would be calling us conspiracy theorists.
Right. And when someone says to you that the only video you have does not show the way he left, he could have left anyway. You have no video of him leaving. No, we don't. We assume he went this way. Well, that's not evidence. Right?
Yeah, it's insane.
If you see an image of Kohberger going into that house and there's no evidence except transfer DNA, but you can solidly show him entering that property, then you have connection.
Yeah. Just like in the Sandra Birchmore case, we see that asshole going in her apartment and then she's leaving and that phone never moves again. You know, like that's the type of shit that's, you know,
it's tragic.
Video of him doing it.
And I'm not arguing for this guy to be innocent. I want the perpetrator, even if it's Kohberger, to be brought to justice.
Yeah.
What I try to tell people is the only thing we should do as citizens, our only job in true crime, should be reviewing the information of our representatives. What did they do to find this perpetrator? What processes did they use?
I'm sorry, but I have a problem. I don't want my rights. I don't want my rights violated either. So
no, and that they trampled this poor guy.
And that's our rights, though. That's what I try to explain to people, though. Bryan Kohberger's rights are our rights because these cases are what makes precedent. And then when you're going to go up against something, like it's fucking ridiculous. And then, so no, somebody needs to slap people across the face that are doing shit that are violating our rights. Like I'm just
you have a bigger following. I want people to hear this because this is important, and it connects to the Kohberger PCA and their warrants. I was arrested for robbing guns out of an apartment. I, in fact, robbed that apartment of those guns. I did the crime, okay? However, I was the painter and the maintenance man in the building that on that specific day of that week, throughout that entire week, before and after, I was painting the hallway. I was painting the doorways, the trim, everything. They found my fingerprints on hinges to the door that was entered to rob the guns. My fingerprints caused them to arrest me. Okay. But the fact that I was in that hallway and I was the maintenance man was a fact to suggest that my prints belonged there. Mm-hmm. Those prints were not proof that I entered that apartment and robbed it. Those prints were only a proof that I was there during the allotted hours for the time that I was there to work, and they had to dismiss the case.
Because it's not probable cause. Because
it's
probable, because your prints should be there. Yeah.
It's suspicion, and suspicion is what is in the argument for the PCA. It's all suspicious. I agree. He's a great suspect, but
it's suspicious.
Not good enough to charge him with a crime of 4 homicides.
That's like getting pulled over. There's like, you know, your reasonable suspicion, but then what we're asking for within your case, or like even this case, is then you're jumping though to probable cause. So, how did they get? They did fingerprint and dusted for skin cells.
Well, how do you dust for skin cells when the majority of your team is walking around in windbreakers? Why is it that you're allowed to use the most microscopic evidence man has ever known, and you collected it like a stumble bum that lives outside? What kind of a fool are you? Do you think Elon Musk or Intel makes their processors and their products in anything but a perfectly clean room? You have to wrap your butt up. You have to get a shower. You have to get blown off. You can't enter a crime scene looking for microscopic evidence while you're running around like Jed Clampett. That's
Jed Clampett, come on down.
Come on now. What kind of country do we live in?
I love it, Sarge. Oh shit.
You're awesome.
I'm so glad you hit the link today. This made my day. Thank you. I love shooting this shit with you.
Yeah,
hey, I'm so glad. But you want to do a heist? Let's fucking I want to make it.
We know how, don't we?
Yeah, let's fucking.
But let me tell you the secret to a perfect crime. You know what the secret to a perfect crime is? is you do it alone. And I'm going to suggest to you that
Probably.
for everything that I see that shows the police can't prove he did it, I can also show you exactly what I see in the way he could have actually done this. And the problem we have right now is we've been full of so much disinformation and theory from the police that nobody's looking at what would make it likely that he did it. His DNA gives you a suggestion he was there, but under what pretenses did he enter that property? Under what circumstances did he get to that house? Do you follow me? Nobody's looking to connect him to what's already in front of us. And I don't invent stories for theories. I take the data that they gave me. I need to put Bryan Kohberger in 11 to 13 Elantra. That exchange of vehicles needs to take place. Then you would have strong probable cause.
Yep.
The coincidence that he drove a 15 is mitigated by the fact that we have a video or we have an image of him getting out of his car going to another Elantra. That would be conclusive. It would fit the data that we were given. It's not me thinking that the FBI misidentified the car. I can't accept that. I accept
and nobody
FBI
will.
told me.
Yeah.
Right.
Especially if the FBI never changed and they were like, no, this is 2013, 2011, and it's because of this.
Right.
You know, but yes, there was a 2014 to 16 that was on WSU's campus. That they were saying, could this be this? And those two things can't be the same.
And let me just say that the insignificance or the minutia of what changes in 11 to 13 and 14 and 16, the minor differences in these two vehicles, folks, are so minor that if it was inconclusive by the FBI agent, this is what would have been in the report. This could have been an Elantra from 11 to 19 because every change in that car was insignificant. It was simple movement of grills. It was a movement of tail light markers. It was a movement of an antenna on the back roof. It was the movements and the change in the vehicle from 11 to 19 are insignificant. So for a policeman to come forward and tell you with clarity that this is an 11 to 13 means he had to have made eye contact with something insignificant because the differences between an 11 and 15 are so insignificant, folks, that unless you really know what to look for, you could never tell the difference as a witness, ever. That's why I never accepted the story the FBI guy changed. He wouldn't have changed. He had to see those tail markers. There's no other way to identify the difference. Fair enough?
Yeah, I mean, as long as the video is clear, I personally think that you could point to things if the video is clear. But I will say that. But I will say that I believe that Payne lied, and that never happened. And here, I'm going to share. This is the motion that's closed for. It's the 21st. On January 21st at 10 a.m. Mountain Time, the court will hold a closed, sealed hearing by remote video means to, one, hear the defendant motion to unseal materials related to its request to suppress evidence stemming from the use of IGG DNA, and two, to consider what portions, if any, and under what circumstances should the various motions set to be heard on January 23rd and 24th be open to the public, either live and or by video. The clerk will provide a video link to the attorneys of record who request a link and to the Ada County Jail so that the defendant may appear via Zoom. The Ada County Sheriff is hereby ordered to provide a secure and private space for defendant to appear by video for this hearing. I want to know what it's going to be super interesting to me. You're going to leave Bryan by himself to watch that, or are you going to send like a lawyer there?
Well, typically he would be accompanied with an attorney. It would be somebody that was connected to the.
Yeah, but I wouldn't want to just watch that by myself in a room where I'm just secluded and it's just me.
Oh, okay. Yeah,
you know what I'm saying? That's what they're trying to say. And so this is the newest drop is, this is it. And so it's just, all it's saying is that we knew that there was going to be, because Ann Taylor wants to unseal the IGG part of it. So on January 21st, there's going to be a Zoom hearing. It's closed because they have to decide what's, she has to make arguments, and then if they're going to unseal it. And then two is to consider what portions, if any, and under what circumstances should the various motions set to be heard on January 23rd and 24th be open to the public, either live and or by video. So they're going to make a decision on January 21st if we're able to hear this suppression hearing And all I have to say is,
how is it that the gigolo
have something to say about this? Because they're the public. The parents are the public, and I'd be one fucking pissed bitch if you're fuck that. Like,
well, I think that if people just pay attention to the narrative that not just YouTubers, but the media and the town of Moscow put forward, their narrative is damning to Kohberger. Their evidence is none. That's the difference in this case. You go look at the Gigolo case. You go look at that guy that killed his wife in Florida. You go look at all these other murder cases, folks. Not only are they not sealed, right? But the fact of the matter is, the evidence that they supplied to us is consistent with the story they're telling us. They've given us no hard evidence to place Bryan in that house, to place Bryan's car near that house, or even if a car was involved in that crime. We don't know because there's no evidence to say at 4:07 a.m., suspect left vehicle. Image of suspect is going to be Exhibit A. There's nothing to connect any car to that. Somebody could have walked in from the backyard and done that. Somebody from could have been hiding out in that house when it was empty and waited for everybody to get in. Right?
This is the motion.
Crazy.
There's a motion. So
Diddy couldn't even get a gag order, says Coco.
Here's the motion. So the defendant's motion to unseal the IGG. This is new. And so comes now Bryan Kohberger by and through his attorney of record and hereby moves this honorable court for an order to unseal the investigative genetic genealogy, also referred to as genetic genealogy or IGG, suppression briefing, and related hearings. So the footnote says the related briefs are: 1, memorandum in support for motion to suppress the genetic information with attached exhibits filed under seal on 11/18/2024. 2, sealed objection to defendant's motion to suppress RE genetic information with attached exhibits filed under seal on 12/6/2024. And 3, the reply to state's objection in defendant's motion to suppress and memorandum in support with is RE genetic information with attached exhibits filed under seal. So it's not only it's the exhibits as well. So this is history. So Mr. Kohberger filed his first motion to compel IGG discovery on June 22nd, 2023. The hearing on that matter was public and involved the testimony of several experts. The court ordered the production of records in camera and under seal. Mr. Kohberger filed a second motion to compel IGG discovery on April 15, 2024. Over the objection of Mr. Kohberger, the court required that portion of the May 30th. So over the objection. So that means like Kohberger was like, no, I want this to be public. So over the objection of Mr. Kohberger, the court required that portion of the May 30th, 2024 hearing on the second motion to compel IGG discovery be closed. The court again ordered the production of records under seal. The court's concerns were the privacy rights of the names of individuals identified in Mr. Kohberger's family tree. At the first and second motion to compel IGG discovery, Mr. Kohberger argued that he would be filing a motion to suppress the IGG. He asked the court to allow the pleadings and hearings to be public. On May 20th, 2024, the court indicated it would take the matter up after the suppression pleadings were filed. Boom. In the interim, venue changed, and this case is now before a new judge. The motion to suppress RE genetic information was filed on November 14th, 2024, and is now fully briefed.
I'm saddened in the fact that a lot of folks that are just stuck on innocent or guilt don't want to even examine the sensibilities of how our representatives apprehended Mr. Kohberger, and the evidence that they claim as evidence is just their theory. Like I keep pointing out to folks, you can't even identify that car as any occupant or occupants as leaving the car. You can't even make that argument. I mean, so to me, it's like a white ghost. It means nothing to me. It's a distraction. So you told me a story about how this kid may or may not have traveled. I could tell you a story about a man named Jed. What does that got to do with anything?
Yeah, I keep saying that. Why are you talking about a dog barking? What the fuck does that have to do with anything?
and it only barked once or twice.
Just because the dog barked, that means what? What are you alluding to? Like you want me to? That means something? Oh, that means what? You think that was Murphy? You didn't say that. You just say a dog starts barking.
What people in
Fucking dogs
America
bark all over
forgot
the
is
place over there.
it's not a policeman's opinion that's allowed to incarcerate you. It's evidence. I don't, like I said, when I robbed that apartment, there was evidence to suggest I was the perpetrator, but there was no hard evidence to prove anything beyond the fingerprint on the hinge. Therefore, the case was dismissed, folks. You can't take your opinion. Well, he's got a criminal record. True. Oh, he was a drug dealer. True. Oh, he was the ever arrested. But I don't care what you say about me. Show me how that fingerprint in an area where I belonged, I was supposed to be there. Show me how that makes me the criminal. And that's how the system is supposed to work, folks. It's really that simple. So you can't come around with an opinion. My 15 years of experience suggests criminals turn off their phone to master location from the police. I agree with that. But let's not forget, Kohberger isn't a criminal. He's a top PhD student teaching others. This kid's got a clean past. He's a regular guy like you and me. All of a sudden, everything he does, you're viewing it through the eyes of a hardened criminal. Most criminals don't know to turn off their phone, for God's sakes. A hardened criminal does. I would never bring a phone with me. I would never drive a vehicle beyond 1999 to a crime scene because you could figure out what it is, where it went, right?
I don't want that Bluetooth.
Yeah. What about Kohberger's statement that they now have his GPS? They can see he isn't there. Why would he offer that up? That was in the statement he made to the police.
Or I'm saying like, hey, give me my phone data so I can show you that I wasn't fucking there, and you're not turning it over. You're not turning it over. You're not turning it over. And then you're saying, where's my alibi? Fuck you. Give me my phone. I'll show you my alibi.
But didn't they let the world believe that those 12 previous trips were him stalking them? Did they not make that clear?
Yeah. So that's all crap.
And then they come out and admit
in
it.
the same PCA that you're saying that like the kids travel back and forth to those campuses all the time. And so like you're acting like that's some big fucking deal. When you just said the same PCA that you want to arrest this guy in, that it's common for kids to go back and forth between the campuses.
Everything they allege, they contradict with reasonable doubt. Every single thing that they do is exculpatory. Every statement in the PCA, they give it a reason why it may not be true. So who was this judge that signed the warrant? That's the person that should be on the hot seat. Not Officer Payne.
I think Officer Payne should be. I don't know if you're lying. If you lie to me and I sign something, I sign, you know what I mean? That's what that case is about. And it's about
the judge should have realized, Lana, that the statements in the PCA weren't a fact. They were based on an opinion. It would have been fine if it were two other witnesses that weren't cops.
I think it's going to come back on both of them. I think Officer Payne's in hot water. And I think, I know that for a fact, Judge in his own order thought that Payne had the car on November 29th. And that he had the car through WSU and had the name Bryan Kohberger on 29th, and making it seem to believe that that's how you got to Bryan Kohberger, and it's not. And that's what I think is going to fuck them.
Gonclaves and the family said that they had heard the first time they heard the name Kohberger was December 15th.
Swirling around or something like that.
Do you remember that statement in that TV interview?
Yeah, but yet the Moscow Police Department didn't hear his name for the first time until December 19th.
Yeah. So. Both can't be true.
I'm gonna read the rest of this though. Let's see. Both can't be true. I love it. On May 20th, the court indicated that it would take the matter up at the suppression hearing. Okay. In the interim, the venue changed. We have this new judge, so the motion to suppress. So here we are. And so now that we are fully briefed, pursuant to court direction, the parties stipulated to file all IGG suppression pleadings under seal. No names of the extended family trees, of the family tree are discussed in the briefing. The matter is set for hearing on January 23rd and 24th, 2025. Mr. Kohberger requests that the briefings be unsealed. He has the right.
Yes, he does.
And that the hearing take place in open court. Boom. Yep. And then those, what are they doing? He's requesting that they be unsealed and that the hearing take place in open court. The hearing to unseal it, because he just labeled this as maybe they're talking about, January 23rd, 24th. So this matter is set. Okay. So I think that's what it's about. So the matter is set for this. Mr. Kohberger requests that the briefing be unsealed and this hearing. He wants this hearing to be open. This hearing that we were having. So anybody out there that's saying that the state wants to hide behind, it is 100% Bryan Kohberger wants the public to see this shit. And so anybody out there that's trying to say that, Brian wants it, normally you have a defendant saying seal it. don't have it, public. So Bryan has that right.
I wonder if people realize that DNA is circumstantial evidence. Are you aware of that?
I mean, I personally think that everything's circumstantial unless I have you on video.
No. I'll clarify. I'll clarify this. If I find your DNA at a market that has been robbed, okay, all that tells us is that you were at that market at some time. Wait a minute.
Yeah.
It's the other facts that I can prove that makes the DNA direct evidence. Do you follow me? Its initial discovery at a crime scene is circumstantial. Now you have to present a case of fact to tie the presence of that DNA, and this is transfer DNA. It could even be saliva. But you now have to build a case to show your footsteps put you in that store at the time of the crime, making your DNA another nail in the coffin for the circumstantial argument that it presents. Here's me. I'm your DNA. How did I get there? That case must be supported by pure fact on how it ended up there and at what time it ended up there. And when looked through an observer, a citizen's point of view, it's factually supported that your DNA is there as a result of your actions. We got you on video. We got witness statements, whatever that may be. Now that DNA becomes a piece of direct evidence against you, where in this case, it's the only evidence against him. It's it. There's nothing else to suggest Kohberger was near those victims except transfer DNA. Right? The whole case is a nightmare because there's no factual evidence anywhere. You don't have the weapon. You can't even say the knife sheath that let's say Bryan Kohberger, he bought a knife sheath in a K-bar on Amazon and they couldn't find it. That's still not direct evidence of anything. Show me how that knife sheath belonged to Bryan Kohberger. Show me that the knife that was supposed to be in that sheath that ended up under the girl, under the comforter, which to me suggests that knife sheath was always in that home, in the possession of one of the poor victims. That's what I see from a closed crime scene. I don't see somebody coming in with a knife sheath, a weapon of war, and not putting it on their belt the way it was designed. It's like going into a crime scene with a gun and you keep your bullets in your pocket and you only load it once you get there.
Especially if there's no defensive wounds, especially if there's no defensive wounds and no struggle in that bed, right?
Well, there supposedly are. Apparently, Kaylee was suffered badly in that struggle.
I don't know.
But here's what I'm saying though. You have a.
I thought it was just different wounds. I thought it was just different wounds. Not that she had.
But do we know it's a K-bar knife that did the crime? We don't know that. The sheath doesn't
what I would be
tell
going
you
with.
what the weapon is.
I would try to, 100%. I would ask a bunch of experts to say, are these wounds consistent with that of just being of a knife, a K-bar knife, or could these wounds even be made with this, knife? Is it indeterminate,
And that knife, just so people know, that's a very hardened blade, and they have the tendency for the tips to break off. I don't know anybody that's used any weapons before, but those blades are very hard. And when you come in contact with a bone or anything, you could potentially, if you move the knife, you bend it any way, left or right, you can snap the tip of the blade right off the K-bar. This isn't some indestructible item. This is like I said, it's a weapon of war, but it does have its pluses and its cons. You don't want to dig holes with it. You don't want to go out in the dirt. If you have to, you will, but you'll destroy the tip of that blade. It'll snap off. So I still want to know what weapon was used. And the presence of that sheath doesn't indicate a weapon, but connecting the sheath to Kohberger is not going to be possible. There's millions of those knives out here. Could be anybody's sheath, right?
Oh, sure.
I'm saddened that they did this all on speculation. Everything they alleged to get that warrant to arrest this kid was speculation. And
I can't believe they would risk this. They would risk this whole investigation to do what they did. And that's what would piss me off as a parent and pisses me off as a citizen. And that you fucking thought that you could do this in this case, and that you would risk, if he is the guy, right? That you're going to risk all of this. Like, who the fuck do you think you are? Type of. That's how I feel for those parents. I would say you better know what you're doing, because if not, I'm holding you personally accountable.
How about when they brag? We surreptitiously obtained a cigarette butt from a suspect and tested the DNA and it didn't match. Okay, you're showing me how smart you are. You surreptitiously, you even know what a big word means. Congratulations. You then secretly obtain a cigarette butt discarded from a potential suspect and ruled him out. Why didn't you surreptitiously take a cotton swab to Brian's doorknob, to Brian's apartment door, to Brian's
anybody
car
would do
handle.
that. Anybody would do that. Yeah.
Why didn't you bring
had
him
his
in for
name so
questioning?
much earlier. Yeah.
That's what they were supposed to do with the IGG tip. And once the IGG tip was confirmed, they should not then have arrested Bryan Kohberger. They should have brought him in for questioning.
Everybody that I've asked that's a police officer says that that's not what they would have done, though. And so that goes with your like, that's why it's like interesting how they're being trained, because
right.
You know,
go ahead. No, say it, because you're telling the truth. It isn't that these are bad people. It's that these are people that are being taught to do things incorrectly.
It's just, well, that I don't know.
Yeah.
They just have a different way of like, they're saying that, you know, why would I tip my hand that we're onto you and type of thing? I'm like, tip your hand.
Because
I mean,
you got snipers keeping an eye on them. What are you talking about?
I was like, I don't think you're tipping your hand when you're looking at a piece of paper and it's like, holy shit, this guy's a PhD student. Like why would his DNA be on this knife sheet? Like, let's look into this. This seems off to me. You know what I mean? Like,
you
this
said
doesn't seem like we're not working with a.
On Christmas Day, you're putting cameras in his parents' lawn. You're following him around when he's jogging. You could have grabbed this. Here's
that's what I said. And then I heard it again. Well, what? So he can flee and then we're in a chase. And then I'm like, flee? You guys are in cars. Where the fuck is that motherfucker going?
Unlike a DNA, unlike transfer DNA, my fingerprint was direct evidence of presence at that crime scene. It was unambiguously direct evidence. It's not circumstantial. Okay? The circumstance now comes to try to understand how and why it got there. And if you can show that there was no reason for me to be in that hallway, that's enough information to take me to court and try me. But if in this case, like with Kohberger, if in fact I wasn't, or I was supposed to be there, or I could show that I wasn't there, my presence of my fingerprint means nothing to nothing. It's unconvictable. Just in the same thing with that's why I'm trying to show folks that DNA is meaningless unless.
Well, to me, it's meaningless when nothing else is attaching it. When there's nothing else attaching it, it's meaningless to me. It's not now. And that's why I look at why they did what they did in the order that they did things, is because I think somebody knew or had some really strong feelers out there to know that these warrants, if we were to get them like, okay, let's go search his car, let's go search his apartment. And then like you're trying to actually build a case and go one by one to get your search warrants. Okay. They wouldn't have returned anything. So then once you're getting stopped dead in your tracks, like, okay, his phone, it doesn't have, there's no social media link. People, there's no DNA of in the car of the victims and then his apartment. I mean, you keep striking out with everything, and that to me is what's hard. Is like
here's a short case in Florida.
Hold on, Sarge. I gotta get going though. It doesn't matter for you. I was ending this at 1 anyways. I gotta go. I have an appointment.
Well, let me tell you 2 minutes on this one case. This is important.
Well, I'm gonna read the rest of this, and I gotta go. I love you to death.
I'll come down.
Okay.
Look up a case in Florida where a husband was convicted of killing his ex-wife, and how they had to go about arresting him. They didn't go arrest him; they arrested his truck.
They arrested his truck.
But the truck contained DNA, and the truck was confirmed to be at the crime scene. Not him. Only the truck was saw. Not a person. So they had to go to the truck to check the truck, the DNA. They found of his dead wife in the truck, and then they went and arrested him.
But isn't his wife's DNA supposed to be in his truck?
Not blood when she's dead on the floor in the garage. And the car was found outside. It was running when a woman went by, and she took a picture of the truck and the license plate. All the cops had was proof of the truck's presence, not the driver. They needed the truck to confirm that truck was part of the crime, and they confirmed that with a DNA test in the truck. Right. Then once the truck confirmed that there was blood in the truck.
Okay, I gotta go though. They
then arrested him for the crime.
Okay. So to close this out, Mr. Kohberger has a right to a public trial, and sealing a suppression hearing is a clear violation of this right to a public trial. I gave Sarge the Irish goodbye, by the way. C. Weaver versus Massachusetts, Waller versus Georgia. Sealing of a motion to suppress to protect privacy of witnesses was error, requiring remand for a new public hearing. State versus Ingram. See also Cowell's Pub Company versus Magistrate Court of the First Judicial District. That's a 1990 case. In addition to Mr. Kohberger's right to a public trial, the public has a First Amendment right to know what goes on in its courts. We sure fucking do. State versus Clapp. Look at that. Idaho Code 74-104 1B recognizes that records contained in the court files of judicial proceedings may be exempt from disclosure under rules promulgated by the Idaho Supreme Court. Wait, what? Promulgated. The Idaho Supreme Court adopted ICAR 32 to define when public access to judicial records may be denied. State versus Doe. When the court is considering whether to seal the record, Rule 32I directs the court to consider, in quotes, the traditional legal concepts in the law of the right to a fair trial, invasion of privacy, defamation, and invasion of proprietary business records, as well as common sense respect for shielding highly intimate material about persons. ICAR 32I3 under Rule 32I1, records may be sealed or redacted if the court determines and makes a finding of fact as to whether the interest in privacy or public disclosure predominates. Finding of fact. So you're going to have to prove that. The court is. The court's decision to seal judicial records is discretionary. Here, the way in which the IGG material was accessed and used is a matter warranting public disclosure and should not be shielded from public's right to know. Yes, we have a right to know how you violate us. This matter is of utmost importance to Mr. Kohberger's right to a public hearing. Holding the hearing in open court will not prejudice the parties, and this should be held in open court. The issues raised are legal issues, and cases with similar issues are being decided in other states. The issues raised in Mr. Kohberger's suppression motion are those that were discussed in the public hearing on the first motion to compel. Additionally, the way in which IGG occurred in this case has been made public in other cases. See State v. Hartman. On that here's your footer. Aspects of the IGG investigation in this case have already been leaked. Aspects of the IGG investigation in this case have already been leaked. Heather Tall Murphy, how police actually cracked the Idaho killing case. Oh God, available at this. Woo! See, stay okay. Boy. Oh, technique, please. Those loopholes. Conclusion. Mr. Kohberger has a right to a public trial, and the public has a right to know how genetic information was used in this case. Neither the state nor Mr. Kohberger will be prejudiced by unsealing the briefing and holding the IGG hearing in an open court. The pleadings and hearings should be unsealed. Boom, daddy. Boom, daddy. So, with that said, there you go. I got to run. I wanted to keep this right at 2 hours. Look at that time. Perfect. I want to thank our boy, Sarge, if he's still in chat. Thank you so much. We love you. So, Sarge, thanks for popping on. Bryan Kohberger wants the world to know. So with that said, everybody, we'll see you back here. Thumbs it up. Thank you, Sarge. Love you. I'm going to make a minor out of a cold. Love it. See you guys soon.
Perfect. You know why we're here?
I see noise.
Noise, yeah.
Yeah.
Big speaker right there.
Yeah.
Nothing against having a party. Once neighbors start calling in, then we have an issue.
Like brains, and like if you need a lot of brains, you're gonna be